What's up, everybody? Welcome back into another episode with the lawyer you know. And today we're going to be breaking down the most recent Daubert challenge filed by the Commonwealth against yet another one of the defense's experts. Why is the Commonwealth doing this? What are they actually objecting to? Is it appropriate for Daubert? And if it's not, what happens? What should be the remedy? Should there be repercussions in place? We are 3 years to the day, literally today, that John O'Keefe died. And still, his family, the victims, everybody involved is waiting for justice. And this trial and this process continues to trudge along with these objections and these filings that create a lot of work and time and money. Are we going to get to a trial date when we're supposed to in this case? Will it be continued again? It seems like there's still a lot to get done. And are these even legitimate motions? We're going to get to all that. We're going to answer your questions today. Let's get to it. All right. So basically, I don't even know if we did a video on the Commonwealth's objection or Daubert motion on Mr. Green, who is he's the Google expert, we'll call him, with the How Long to Die in the Cold Googles by Jennifer McCabe. He is the one that said these searches were made on or before 2:27 a.m. We're going to get into that. But basically, the gist of the Commonwealth's motion is he came to the wrong conclusion. He considered reports and things that changed. What he says is wrong. His end result is wrong. Okay. And we're going to couple this with the fact that we know they filed the Daubert challenge and had a hearing on Dr. Russell, which they lost as the Commonwealth. And then I think they have filed or said they were going to file Daubert motions and try to strike the ARCA experts, the accident reconstructionists. So it seems like they're just filing these motions against everybody. And I will say that it's not inappropriate to file a Daubert motion if you think you need to strike an expert. It's not inappropriate to ask for a hearing. It's not inappropriate to question that witness at the hearing. And I'm going to get in and I'm going to weave in some of our experience doing that at my firm, because in Florida, you are allowed in felony criminal cases to depose witnesses. So you don't need a free deposition. But in federal cases, you're not. And the discovery rules are much tighter. And in Massachusetts, you're not just allowed to take the deposition of this witness. So I'll tell you about some of our experiences of filing Daubert challenge, when they're successful, when they're not, when it's appropriate, when it's not appropriate, how lawyers actually are, what judges usually do. And we can kind of compare how this case is going as well. So first paragraph or first page, we're just going to skip where they say you should deny the motion. This is all wrong. And we're going to get to kind of the meat of this. We're going to read this, and then we're going to read a couple chunks of Richard Green's affidavit as well to give more context and information to what's going on in the background. The motion of the Commonwealth to exclude the trial testimony of Richard Green is just the latest in the Gatling gun dystopian approach of the Commonwealth to deny Miss Reed the ability to present her defense through her well-credentialed, methodically reliable expert witnesses so she can have a fair trial against the baseless charges lodged against her. So we're going to see dystopian and Orwellian, and basically we live in an unjust world, especially here in Massachusetts, is what the defense is saying in this motion. The expert witness of the defense here, Richard Green, testified as an expert witness in digital forensics in the first trial regarding his opinion that the Google search, How Long to Die in the Cold, existed in the data from the iPhone 11 of Jennifer McCabe with the timestamp of at or before 2:27 a.m. and in a deleted state without any objection from the Commonwealth as to his qualifications or methodology, and for good reason. Mr. Green has been accepted in several United States courts as an expert in digital forensics. So let's just take a second here and talk about that, because the without objection from the Commonwealth in the first trial basically means the Commonwealth has already agreed he's an expert. And the judge, after hearing his testimony, didn't step in and say, this is junk science. We can't let this guy testify, as if it was so horrible and off the wall the way his methodology, whether it was generally accepted in the scientific community. It all already came in. It all already happened, because that adds an element here. I've been talking to my dad about a couple different cases, and this is one of them, just what the Commonwealth is doing. And, you know, he says stuff like, yeah, I mean, they really have an issue and they want to get some more discovery from the expert, and you do this. It's like, well, fine, but they already testified in the first trial, first off. Secondarily, they're not attacking his methodology. They're not attacking his education or his experience. They're attacking the end result and his opinion. And a difference of opinion is not an appropriate remedy or not an appropriate thing to have a Daubert hearing for. Additionally, wanting this free deposition, right? A lot of lawyers will joke about it. Some lawyers I love and respect will say, yeah, I would do it. Get that free deposition. Strategy is what lawyers do. We're fighting zealously. It's like, yeah, but zealous still needs to include ethics. And in my opinion, it's unethical to file a Daubert challenge, ask for a hearing for an improper purpose, which if all you want is a deposition, so you file the Daubert challenge, that's circumventing the rules where you're not supposed to be entitled to a deposition. And you may ask why. Why not? I think it's stupid. I think we should allow depositions in cases, but the rules are written specifically in a way and in a matter of what they think is the best for the justice system. And when the people writing the rules and ratifying the rules and working under the rules and interpreting the rules all understand that you can't depose this witness in this situation, they did not then add the Daubert section of, sure, just ask to challenge this witness and you get a free depo in court. In fact, recently, the Florida rules all across the board have gone through a huge overhaul of changes, and we're actually mirroring the federal rules a little bit more, not quite to this extent. But one of the things we talked about in the Civil Rules Committee was, do we want to add some language into the Daubert section, into the expert witness section, so that judges know they don't have to order a hearing? Because almost every time we file a Daubert motion, we ask for a hearing. And I would say 90+% of the time we get that hearing. It's if you can write a good Daubert motion, you're going to get a hearing. You don't win 90% of them. You probably lose 90% of them, right? In federal court, there have been times where we haven't gotten a witness struck altogether, but we've struck 75, 80% of what that witness was going to testify to. It's happened to me as well. It just happened in a recent case where maybe 25% of what I wanted the witness to testify to, he wasn't allowed to. So I can say he's educated, he's experienced, he knows what he's talking about. But sometimes you get in a scenario with the lawyer where it's like, maybe I can ask him one or two more questions. And the judge is like, no, I don't think that actually fits in his expertise. That's an appropriate Daubert motion, even for a very well-educated, experienced expert. But that's the appropriate remedy and way to do it. But we were finding that judges were almost just always giving a hearing. And sometimes that's a waste of time and that's a waste of money if it's somewhat obvious, or if you can just do it on the papers, or say, take a look at in our situation, a deposition transcript, because we can do that here in Florida. And we went back and forth because usually in the rules, you don't want to put something in the rules that's already there. And it's already there that a judge can deny a hearing. So for us to put another paragraph in being like, judges, you don't have to grant this hearing. We want to empower you. We just want to make sure you know you don't have to grant the hearing because it wastes a lot of judicial resources and money and time. And we've got to pay these experts and the clients have to pay the lawyers. So it is a very legitimate concern because it does take a lot of time, money, resources, etc. But, and I'll just use Dr. Russell as an example, okay? I think she was so qualified. I think she had great education, great experience, really interesting experience for that specific issue of it being a dog bite. But I do understand the questions asked by the Commonwealth to say, can she really do it? And if we didn't have the first trial, I think that would have been a totally normal Daubert challenge for the Commonwealth to make. But when we go into Mr. Green and to the ARCA experts, to me, these are just facially inept. And they just don't get at what you're supposed to get at when you challenge an expert for Daubert. And we're going to go through and we're going to discuss the defense's responses to what the Commonwealth said, but it almost seemed like the Commonwealth's not even trying to get them struck. That's the feeling I get. There are some good things for cross. I do think there are some good things for cross for the Commonwealth that they're going to be able to argue to a jury, but that's not the same thing as a Daubert motion. All right, back into it. The methodology that Mr. Green employed in the first trial was the same methodology that the proffered experts of the Commonwealth employed. That is, Mr. Green and the two proffered experts of the Commonwealth received the same raw image file from Jen McCabe's iPhone 11, verified the hash signature / value of the image file, took the image file, saved it to their computers, servers, hard drives, etc., and then processed and evaluated the image file with the appropriate tools such as Cellbrite Analyzer and Magnetic Forensics Axiom. While Commonwealth witness Ian Whiffen used only the Cellbrite physical analyzer and Artex tools, Commonwealth witnesses Jessica Hyde historically used 3 more tools than Ian Whiffen. And Richard Green used at least as many tools as Jessica Hyde, with Green and Hyde using 4 of the same tools. So very similar methodologies, right? You can say he's wrong in how he looked at it or he's wrong in how he interpreted it, fine, but they can't possibly think his methodology is wrong. It lines up with what the Commonwealth did. Notably, although Jessica Hyde previously used 4 of the 5 tools used by Richard Green in her initial analysis, all but Cellbrite are now disconcertingly absent from her December 2024 report submitted with the Commonwealth's motion, despite her admonitions in her previous reports that it is best to use multiple tools. So Hyde now is going from, I used all these tools, to just this one, and we'll find out why they're really going to focus in on that Cellbrite as the only possible way to get this answer. But you better believe on cross-examination, they're going to ask her, Ms. Hyde, isn't it true the first time you did this, you used X, Y, and Z? Very similar to the methodology used by Mr. Green. And isn't it true you actually said it's better to use more than just one tool? So that's going to be something they're going to be able to cross-examine her with. If she does come and say, oh, only one report or only one tool is what I needed. Importantly, sorry, I had a small piece of ice. It was undisputed by all experts at the first trial that the 2:27 a.m. search artifact was indeed present on the iPhone of Jennifer McCabe after analysis using Cellbrite physical analyzer forensic tool technology available and on the market at the time. It is thus completely inexplicable how the Commonwealth can now challenge the methodology of Richard Green, whose methodology is the same as and then more comprehensive than that of the digital forensic witnesses of the Commonwealth. It is the opinions and conclusions, not the methodology of the witnesses, that differ, but that difference is not a Daubert-Lanigan issue. So this is the basic, this is the gist of, I can't highlight it. This paragraph here is the gist of this entire motion and why I think this is not even an appropriate Daubert challenge, because they're arguing with the opinions and conclusions, not the methodology, not the education, not the experience, which difference in opinions and conclusions is something you deal with the jury. The finder of fact has to make that decision. What has changed since the first trial? The answer is disturbingly Orwellian and brings the prosecutor closer to, if not squarely within, the danger zone of legal tyranny. We know we're going to have language like this in these motions. After the first trial, the proffered expert witness for the Commonwealth, Ian Whiffen, a law enforcement centric digital forensic consultant, appears to have gone back to his company, Cellbrite, to have its researchers perform further updates to its physical analyzer programs, such as the artifact containing the 2:27 a.m. timestamp has now suddenly disappeared from all Cellbrite programs. It has nefariously become, without explanation, the Orwellian unperson. What just happened? That was weird. So what they're saying is Ian Whiffen went to Cellbrite and basically said, this is what they're accusing him of, okay? That Ian Whiffen went back and nefariously got that removed. And now it's not showing 2:27 a.m. at Cellbrite in that report at all. And Whiffen's going to say, oh, it was something wrong with how they reported. It should be like this. It's confusing when they use these timestamps. They're not going to use those timestamps anymore. We know that because that's what he testified to in the first trial. And that's fine. But once again, the defense is going to have yet another argument that, look at this cover-up. Look at the lengths that they're trying to do to change the evidence and make it disappear. And this all works into the conspiracy of them making everything line up for them, because every fact that turns out to disprove their case, they try to make it go away. And frankly, they have so much more fodder in this case than you usually have in a case where you may call cover up or that the cops are doing something nefarious or whatever it may be. And you can add this to the list. Their expert literally went back to Cellbrite, got it changed, and something that used to exist on a report during the first trial now no longer exists. Which, guess what? That's fine. And that's good evidence for the Commonwealth. Cellbrite fixed their issue. And now when you run the report, it doesn't show at 2:27. And that's the appropriate report because this happened at 6 a.m., not 2 a.m. Fine. The Commonwealth can testify to that. But the defense should be able to present to the jury how it was originally, what it was like before the Commonwealth expert went back and got it changed, how everybody was on the same page that it used to show the 2:27 a.m. Google search, and the fact that the defense believes that the evidence shows it was deleted. Once again, that's up to the jury at the end of the day. That's really what it comes down to. Michelle said, motion to strike ARCA experts on a Rule 17 discovery motion, not a Daubert issue, except the feds have that discovery, not the defense. Rule 14. Okay, so that they didn't turn it over in time or, okay, I'll have to look at that. I haven't seen that, but thank you. That's a very good and important distinction because I just wouldn't understand how they could possibly have a Daubert challenge for them. Is there a word for legal malingering? That's what I see the Commonwealth doing, wearing down money, time, and resources. I'm not sure if malingering would be the right word for that, but a lot of civil defense firms and insurance companies try to do that where they just bleed people dry and they try to make them so miserable to where they just give at the end of the case. And we'll talk about that if that's something that's potentially going on here. After Celebrate completely rid itself of the 2:27 a.m. search that is incredibly inconvenient to their theory of the case for the Commonwealth now comes before the court saying the unilateral and unexplained Celebrate updates to remove 2:27 a.m. search artifact should control whether a jury is able to evaluate whose digital forensics theory about the artifact is most accurate. And in doing so, glaringly, the Commonwealth does not address the other forensic tools such as magnet forensic axiom that Ms. Hyde used in 2023, that Mr. Green used in the first trial and continues to use up to this day, and still contains and shows the 227 search artifact, nor the several other digital forensic tools that Mr. Green used. So it almost sounds like the Commonwealth's like, the only thing you can trust and the only tool you can use is the Celebrate one. And I would almost say, frankly, if I want to, just kind of be a lawyer on the outside and I want to come in and somebody asks me what seems to be the most reliable tool, I might say, Judge, maybe not the one that all it takes is for a guy to go back and it changed it. And now we don't really know if we can trust these reports because it changes what it's spitting out. As opposed to the expert had an explanation as to why he believed the 227 was not actually what it showed to be, which I was okay with. I was like, that's plausible. Like, the website was up, and you went to bed and you wake up and you open your phone, it's that same website reloading, and then you do something else. So that's why the time is showing, last night versus when you woke up. He had an explanation. That's part of how trial works. But now to just have it removed, it feels a little weird for me, even though I think it could be very legitimate because Celebrate's like, hey, that was wrong. We're always improving. It's technology. We wanted to make a better program. And now we have a better program and it actually spits out what it's supposed to. I understand that as well. Doesn't make this an appropriate Daubert challenge, in my opinion. Additionally, the motion for the Commonwealth is legally insufficient on its face. The motion is not supported by one affidavit. The motion does not even begin to meet its going forward obligation to state how Mr. Green is now, suddenly after the first trial, supposedly not qualified. Nor does the motion even begin to identify what the Commonwealth believes is the proper methodology to address the 2:27 a.m. search artifact, or why the methodology employed by Mr. Green to analyze it is not reliable. Perhaps this failure is due to the fact that Mr. Green is eminently qualified, including more qualified in data forensics than Mr. Whiffen, and that the methodology Mr. Green employed include the same and entire methodology of the proffered witnesses for the Commonwealth, plus this addition of additionally accepted digital forensic tools. To prevent the continued abuses of Ms. Reed by the Commonwealth, including the bleeding of her financial resources and distractions from her and her defense team's preparation for trial, the invasion of the province of the jury, and other broader jurisprudential maladies, this court must deny the Commonwealth's motion and its included request for an evidentiary hearing. So they really want the judge to say, you don't even need to have a hearing. Because what does a hearing do? Well, we got to pay lawyers to show up. We got to pay experts to show up. We got to take time off work to show up as a party. Our family is going to show up. The people that support us are going to show up. It just is a waste and a drain. And that's why it's really important to only allow, I'm trying to show you guys and tell you guys how it works in real life, right? In real life, most of the time you get the hearing. If you file a motion and it's got some semblance of reality to it, you get the hearing. You argue it, you get your day in court, and the judge makes a decision. But how many days of hearings are we going to go through for experts that were already allowed to testify in the first trial, either without objection or over objection, because the judge has already decided, like she did with Dr. Russell in the first trial? How many of these are we really going to do? Because one party's paying out of pocket while the other is government funded. And so the court needs to look seriously at this and say, is there an issue that's appropriate for a Daubert hearing? Is there a problem with his education, his expertise, with his methodology? And if she believes there really is an issue with his methodology, then fine, have the hearing. But if it's just a deposition and a disagreement with final conclusions and opinions, we just shouldn't waste more time with a hearing. Case history of the digital forensic analysis of the 227 artifact. For 3 years in the case, there has been no dispute over the methodology employed by the defense to address the issue of the 227 search artifact. Richard Green testified at the first trial as a defense expert without any objection to his qualifications or methodology. As he stated in that testimony, after receiving the raw image file of the data contained on Jennifer McCabe's phone, he used 5 digital forensic tools to evaluate and analyze on the image file. Those findings were consistent with the April 24th report. Trooper Nicholas Guarino, who testified as a proffered expert of the Commonwealth at the first trial, Mr. Guarino reported that while the 2:27 a.m. search artifact did not appear on the version of the Cellbrite physical analyzer he had used for his May 4th analysis of her phone, Mr. Green used the then newest version of the analyzer, which did depict 227 search artifact. Which is also important, right? If it's like, yes, it shows it. Now it doesn't show it. Well, now it shows it. To use other tools and programs, to me, would bolster that testimony. The newest version was able to pull an artifact, How's Long to Die in the Cold 227, that was deleted. Inexplicably and unexplained up to this day, Trooper Guarino did not disclose in his report of April of 23 that the Axiom program he used at the same time did show the 227 search artifact. So, Guarino, everybody's favorite guy, for potentially his work in some other cases as well. Turns out he used Axiom, which is what Green used. And while the Cellbrite one, he has some plausible deniability. It didn't show a 2:27 a.m. Google search. So I'm not going to put that into my analysis as a cop if it doesn't show up, right? So he could say, hey, Cellbrite didn't even show up the first time I did it. Then when Green did it, it showed up because he used a newer version of the program. Well, Guarino also did an Axiom search, and it showed up in April of 23, which was later than the May 4th of 22. But why was this never disclosed? And the fact that it exists, to me, once again, if I'm the judge, I don't need a hearing on this. All of the proffered experts or experts that have already testified at trial agree that this is the way you do it. Now, what you do with what the tool spits out, that's up to the expert, right? And if he said, I wave a magic wand over this document and it, goes up into my head and that's how I make my decision, sure, we have an issue. But he uses the same methodology as all of the other experts in this case. Mr. Green's findings were further consistent across all 5 tools that he employed, and remain consistent with the findings of January 2025 from analysis performed in the most recent version of Axiom, which contains the report of 227 AM search. Like Mr. Green, Mr. Whiffin's methodology was to use digital forensic tools to analyze the raw image of the data from Jennifer McCabe's iPhone. So the other thing that the defense is pushing on this judge is, Judge, are you really going to make the call that the only digital forensic tool that you can use in this courthouse or courtroom is Cellbrite? I don't think you can do that. And we have other tools that experts have been using for years that have been appropriately testified to in this court. Unlike Mr. Green, however, Mr. Whiffin used only 2 digital forensic tools in his analysis, Cellbrite and his company's tool, Ardex. After performing an analysis using a then on-the-market Cellbrite analyzer program, Mr. Whiffin testified at the first trial and reported that he saw the 2:27 a.m. search. So the 2:27 timestamp was correct in so as far as is the time is shown within the database. It was indeed a deleted record. That's from his testimony. Thus, while he disagreed with Mr. Green's opinion about whether the information indicated a search for How's Long to Die in the Cold was conducted at 2:27 a.m., he did not dispute that this 2:27 a.m. search artifact was present in a deleted state during his analysis. Now, he had an explanation for it, and I think it's one that a jury could potentially buy. But that doesn't mean that if you have a difference of opinion on something that did exist, that just is scientifically unreasonable. It's junk science and you can't testify to it in front of a jury. Jennifer Hyde also employed this methodology, originally using Cellbrite Analyzer in all these programs. 4 of these tools were among the 5 used by Mr. Green in his analysis. In her May 23 report and in her testimony at trial, Ms. Hyde agreed with Mr. Green and Mr. Whiffin that she had seen the 2:27 a.m. search. She also admitted in her May 23 report that the 2:27 a.m. search appeared in a deleted state. She disagreed with Mr. Green's opinion about whether the information indicated that a search for House Long to Die in the Cold was conducted at 2:27 a.m. But she didn't dispute that the artifact was present, and that's the point. They're trying to say now with the new Cellbrite program that shows that 2:27 artifact doesn't exist anymore. Therefore, nobody who knows what they're doing and applies this methodology appropriately could ever say that 2:27 a.m. exists. The problem is some of the other tools say it still exists. Inexplicably, Miss Hyde changed her analysis and findings from her May of 23 report to align with Mr. Whiffen and a Cellbrite manipulated update to one physical analyzer program, which the defense learned about approximately 1 week before the trial began. Magically removed the 2:27 timestamp value from the records sourced from the Safari's browser state.db. Using only this updated Cellbrite tool and no others, Ms. Hyde drafted a new report in December of 24, taking back, without explanation, her original conclusion that the artifact containing the 2:27 a.m. timestamp was present on the iPhone of Jen McCabe in a deleted state. She opined instead that the artifact containing the 2:27 a.m. timestamp was not present in a deleted state or otherwise, citing merely an unsupported, conclusory, and scientifically insufficient assertion that the timestamp was not reliable. So, this is always a strategic decision for a lawyer. Do you want your expert to change their testimony or alter it at all? Or even if it doesn't change the ultimate opinion, alter something in it like this. And we saw the Commonwealth go all over Dr. Russell for any changes she had. Even if it was just like, I'm pretty sure it was this too. Now I'm sure it was this. Or it could have been that. It could have been that, but it's more likely this, right? That's a subtle change, but it's still a change. And they hammered her for it. Well, this is something the defense will absolutely hammer Ms. Hyde for. You just completely changed it. So you got together with Whiffen and with Cellbrite, you changed it, and whoop, magically it disappears now. So your prior report, they're going to be able to impeach her with her prior trial testimony, her prior reports. Those are going to be prior inconsistent statements. But the Commonwealth and Hank Brennan feel like this was a necessary risk to take in order to tighten up this case, have everybody on the same page, say that 2:27 a.m. never even happened. It doesn't even show up in the most trusted and best tool that we use. There were some bugs that needed fixing, like happens in technology. Once the bugs were fixed, it doesn't show up because it doesn't exist, because it doesn't happen. And he thinks that's a stronger argument, and they'll deal with the impeachment on cross for Ms. Hyde. The Commonwealth simply makes the same bald, conclusory statement as Ms. Hyde, that further research shows that the timestamp is not a reliable source for a timestamp relating to the URL shown. The Commonwealth provides no explanation for that assertion, nor does it provide any information as to the reasons why that supposed research allegedly finds the 2:27 a.m. search artifact, and this artifact alone to be unreliable. It also provides no information about the methodology of the research or any other information regarding what changes were made, how, or why. Critically, despite the manipulation associated with the unexplained update, the accompanying sudden change in the analysis of the Commonwealth's proffered experts, Ms. Hyde's second report, dated December of 2024, does not represent a different methodology, but rather a narrowing of and change in opinion about the presence of the 2:27:40 a.m. search artifact. In the second report, she employs the same methodology as she did in the first trial and as Mr. Green and Mr. Whiffen employed, but the least mention of an inconvenient Axiom tool she used in her May 23 report, which as of this date, the date of this opposition, continues to show the artifact containing 2:27 a.m. timestamp in a deleted state to reach a different conclusion. The only difference, in fact, between the application of the methodology by the Commonwealth's proffered experts and the application of the methodology by Richard Green, as that the former is entirely encompassed by the latter, Mr. Green simply used more tools in employing the same methodology and thus was able to conduct a more thorough forensic data analysis. Do you guys say data or data? I find myself going back and forth and using both. I just like it. The appropriateness and reliability of Mr. Green's all-encompassing methodology is evidenced by the fact that all experts agreed and opined at some point during the first trial that the 2:27 a.m. search artifact existed and appeared in a deleted state. That's it. I mean, that should be lock and key. Using this methodology, using these tools is appropriate. Everybody saw it at first. The Commonwealth experts, I'm not going to say they shouldn't be allowed to testify that it's wrong, that it wasn't 2:27, and that the updated tool is actually right. It should have never existed there. They can testify to that. They're free to. They're experts, and they have an explanation as to how they got there. But Mr. Green should 100% be able to also testify to what his experience and expertise and training and what he did with the rules and the reports show. This is a criminal defendant with her literal life on the line. You cannot strip her of her right to defend herself. That would be unimaginable to me. Mr. Green's methodology is further supported by Jessica Hyde's testimony that it's important to use multiple tools, which they've said multiple times, and different data sets to be able to compare those results and enhance those with manual analysis. And that doing so is absolutely pertinent and allows her to ensure that she's getting the most complete interpretations. This mimics the approach of Mr. Green and is counter to the myopic and company biased approach of Mr. Whiffen, to which Ms. Hyde now disquietingly has morphed. The experts' disagreement is not over the methodology, but rather their opinions on whether the 2:27 a.m. search artifact indicates that Jennifer McCabe conducted a search for how long to die in the cold at or before 2:27 a.m., contrary to the assertion of the Commonwealth. Okay, so this is just the battle of the experts, right? And that's what it feels like to me too. There was something I want to mention here. Oh, so quotes like this that are great. What Ms. Hyde said in the first trial, what she said in the first report. These are the types of things that good lawyers use to their advantage in the fact that we've already done this trial once. And so many of the arguments contained in this motion that are very strong arguments go right back to the fact that we already have a lot of this testimony on the books and they should use it and they should know what it says. The 227 search says deleted state. Whiffen says nope. Jen said she searched Hawkbrook basketball at that time. Why wasn't that deleted? I can't say I remember this testimony like the back of my hand, but I know that both sides experts had explanations for just about everything. Some of it I made total sense. Some of it I was a little on, but I did think that it's going to be up to the jury to parse through and make the decision on. Thank you, Chris, for gifting a membership. All right, let's get to the argument here. The motion of the Commonwealth is deficient. The Commonwealth's motion to exclude certain expert testimony of Richard Green is deficient on its face in the two aspects of Daubert-Lanigan application to this motion. The Commonwealth claims Mr. Green is not qualified and that his methodology is unreliable, but provides no explanation as to why. In fact, the Commonwealth doesn't even describe the methodology of Mr. Green, which it asserts is unreliable and seeks to exclude. And that's why it kind of feels to me a little bit more like I want to take this guy's deposition. The Commonwealth's motion is not only bereft with respect to the prongs of the Daubert-Lanigan inquiry, qualifications and reliability of methodology, but also with respect to other aspects of its analysis. Nowhere in the motion does the Commonwealth discuss the general acceptance precept of Commonwealth v. Davis or the 5 non-exclusive factors of Daubert. What little the Commonwealth does say about the law is rote and does not address the question at issue here. The Commonwealth also fails to mention that the Commonwealth versus Rintala instructs that the crucial inquiry for Daubert-Lanigan purposes is whether the proffered expert is qualified. Mr. Green overwhelmingly satisfies the Daubert-Lanigan standard. And I do like the way this attorney, Alessi, I believe is the one who wrote this motion. I do like how he focuses. The beginning was a lot. He put a lot in there. But when he gets to the actual argument, he focuses so specifically on the analysis, the prongs, the factors, what you specifically need, and everything else kind of be damned. And that's the best way to win motions like this, is to focus narrowly on what question the judge is answering. The judge is not determining whether Karen Reed is guilty or not guilty. She is just determining reliability, expertise, education, methodology of this expert. The motion of the Commonwealth is not supported by any affidavit. Commonwealth additionally misses the point of a Daubert-Lanigan inquiry. It argues, for example, that Mr. Green's opinions to the artifact at 227 lack any evidentiary support, cannot be made in good faith, constitute baseless claims. These claims, in addition to being false, have no relevance to the methodology inquiry. They relate only to cross-examination and jury determinations, which was a lot of the kind of questions he was asking to Dr. Russell. I think Hank Brennan brought up some good stuff that he's going to be able to cross-examine Dr. Russell with. They weren't really good arguments against Daubert. Even if it wasn't deficient on its face, it still doesn't meet the requirements of Daubert. Broadly, the Daubert-Lanigan inquiry involves evaluation of both the qualifications and methodology of the proffered expert. However, the crucial issue is determining whether a witness is qualified to give an expert opinion, is whether the witness has sufficient education, training, experience, and familiarity with the subject matter of the testimony. In addition, under Daubert-Lanigan, the judge acting as gatekeeper is responsible for making a preliminary assessment whether the theory or methodology underlying the proposed testimony is sufficiently reliable to reach the trier of fact. Whether the scientific theory or process, one has been generally accepted in the relevant scientific community. We're all learning together, right? You read so many Daubert hearings or motions, you guys should start to understand what is it that we're looking for in experts that use Daubert, of course. Has been or can be subjected to testing, has been subjected to peer review and publication, has an unacceptably high known or potential rate of error, and is governed by recognized standards. When applying the standard, judges must be careful to not invade the province of the jury. Critically, it is the qualification. And what that means in this situation is not to invade the province of the jury is this expert right? The judge is not supposed to answer whether they think, in fact, Jen McCabe searched at 2:27 a.m. How's long to die in the cold? That's not what Judge Canoni is supposed to be determining here. That would be entering the province of the jury. Critically is the qualification and methodology of the expert, not their conclusions, which the judge is tasked with evaluating. Differences of opinion present issues of credibility, which are properly reserved for the jury. Accordingly, expert witness testimony should not be deemed unreliable simply because there is a disagreement of opinion or in the level of confidence among the experts. Because the judge disagrees with the expert's opinion or finds the testimony unpersuasive, that shouldn't be a reason for them to make the determination. Such disagreements make up the battle of the experts. Richard Green's education, training, experience, and familiarity with digital forensics qualify him as an expert on the topic. By the way, thank you to Sleuthy Goosey for sending this to me. It's been so busy. I haven't had time to pull up these documents. A lot of people ask me about them. Sometimes I don't do them just because I literally don't have time to go search and find them. So I really appreciate that. Anybody that sends me an actual document when you have a question on them, appreciate it. As to the crucial inquiry of the Daubert-Lanigan standard, the proffered expert's qualifications, Mr. Green clearly satisfies the requirements of the standard. Mr. Green has more than 25 years of experience as a computer forensic technician and more than 18 years of experience conducting electronic data analysis and investigations. Mr. Green has been accepted as a digital forensic expert approximately 24 times in the United States. He was qualified and testified as an expert the first time in 1996 after spending approximately a decade working in computer information technology and networking, building a line of computers, and doing computer repairs. Mr. Green started a digital investigation firm called United States Forensics, which he still owns and operates today. His company handles between approximately 100 and 120 cases per year and receives annual inquiries for about 3 times as many cases. His company has worked on civil and criminal cases across the country, both state and federal court, and on behalf of both defense and law enforcement teams. Since starting USF nearly 2 decades ago, Mr. Green has worked full-time in digital forensics. In addition to being the company's president and founder, he performs the majority of the investigations. All right, he's got a lot of education experience. Okay, I don't want to go through all of this, but he's got a lot of education experience. He holds an associate degree in digital forensics and computer investigations. Now, somebody can say associate's degree, is that really enough? It's not a doctorate, et cetera, et cetera. But education is part of it. And if they wanted to, if the Commonwealth wanted to say associate's degree, not enough, and explain why, they should have done that. They didn't. And I think one of the reasons they didn't is because some of the people that are going to be testifying to certain things that might be expert testimony for them also hold an associate's degree, if you remember, and back to the trial. Which again, associate's degree is not a bar to be an expert, especially if you have 25 years of experience doing exactly this. And they just kind of going through, he's a keynote speaker. He does this every day for his work. In total, he's participated in hundreds of training events. He's attended 67 of the trainings. On December 31st of 24, despite Mr. Green's robust digital forensic credentials and experience, the Commonwealth moved to exclude the proposed testimony of Mr. Green as the 227 search artifact. The Commonwealth's motion should be denied. What's also interesting about this is, always remember too, from the expert's point of view, I don't think Dr. Russell really cares. I think she wants to do the right thing. I think she's a caring person. That's not what I mean. But for somebody like Mr. Green or Mr. Whiffen or Ms. Hyde, this is their job. So if you go get Dauberted out and the judge is like, yeah, this guy uses some wild methodology that doesn't seem scientifically accepted. This seems like junk science that this guy's using, that can affect your career. So you better believe that these kinds of expert witnesses are going to do everything they can to help this defense team, to give him whatever they need to make sure he doesn't get struck, right? Nothing unethical or wrong, but they care about this. They have a vested interest in not getting struck. Not necessarily a vested interest in who wins the case. They're going to do their job. They're going to testify. They can't control what a jury does. But it is not a good look when an expert gets struck. Because then usually that's a question for every future deposition. Have you ever been disqualified before? Have you ever been found to not overcome a Daubert challenge? Okay, what happened in that case? Ask questions like that. The education, training, and experience described above is not only overwhelmingly in its own right, but much more significant than the proffered prosecution expert Ian Whiffen. According to his own trial testimony, Whiffen has testified in the United States only once in his entire career. Mr. Whiffen also admitted at trial, unlike Mr. Green, he has no specific certifications in digital forensic other than a higher national certificate in computing, and does not have a degree in digital forensic or otherwise. AA is better than nothing, right? Or an associate's degree. By proffering Mr. Whiffen in as an expert, the Commonwealth has tacitly affirmed its belief that Mr. Whiffen is qualified. Accordingly, the Commonwealth's arguments regarding Mr. Green's qualifications should be rejected. Bada bing, right? If you have the more experienced expert, it's always a good argument to be like, look at their guy. He doesn't have nearly what our guy has. Contrary to the Commonwealth's contention in their motion, Mr. Green was not broad and vague during cross-examination. Mr. Green answered clearly and completely the only question the Commonwealth asked him about his training experience and certifications. Out of the 5 digital forensic tools Mr. Green used to evaluate the data from Jen McCabe's phone, Attorney Lally chose one, Cellbrite, and asked Mr. Green if he had a certification for that particular platform. Mr. Green stated clearly after seeking clarification of the question that he had no such certification. He added that his certifications are much broader, as they concern digital forensic fundamentals, how to conduct investigations, which tools to use. His answers were specific and appropriately detailed. The Commonwealth's statement is thus incorrect. Again, if Judge Cannone wants to say, only thing we care about here is Cellbrite, that's the only thing you can use, well, she's free to do that. I think that'd be a mistake, but that's the only way you even start to consider whether Mr. Green is not an expert in what he's testifying to. Curiously, according to the Commonwealth's own argument by omission in this motion, Mr. Green remains qualified, and his methodology is reliable in the several areas of data forensic he testified about in the first trials. They're saying they didn't specifically say he's not qualified because of this, therefore, by omission, they're saying he's qualified. The Commonwealth challenges none of those several areas of digital forensics, namely the call logs deleted from Jennifer McCabe's phone, the screenshot of the contact for Uncle Brian A. deleted from McCabe's phone, the location data from Jen McCabe's phone, the health data from Jen McCabe's phone. So basically they're saying they didn't object saying he couldn't testify to any of this stuff. They just focused on that. So again, are they saying the only way you could possibly be qualified is if you are certified by Cellbrite? The Commonwealth did not challenge Mr. Green's qualification as to these topics is further evidence of his eminent qualifications. Such a challenge would fail, as should this one. All right, Green's methodology is reliable. The Commonwealth's papers fail to identify a methodology for Mr. Green, let alone state why his methodology is flawed. And in fact, the Commonwealth cannot make such a statement because Mr. Green not only applied the same methodology as the Commonwealth's proffered experts, but expanded upon that methodology by using more tools, performing additional low-level analysis, and examining overall user activity. The validity of Mr. Green's methodology is evidenced by the fact that all experts employed it and acknowledged at some point during the first trial that the artifact existed. Okay, we already read that. It's kind of repetitive of what he did in the beginning. Commonwealth now asserts Mr. Green's methodology is somehow unreliable. They provide no competent evidence to support this contention. The Commonwealth claims Mr. Green admitted that his misinterpretation of data caused Cellbrite to update its physical analyzer program to remove the artifact of 227, but a proper reading of his June 21 testimony transcript makes it clear that the question was poorly stated to the point of incomprehension. In his answer, Mr. Green was making the point as of June 21st, 24, Cellbrite had 2 contradictory versions of physical analyzers on the market. In one version, InSayet's physical analyzer 227 AM search artifact had been removed, while in another version, physical analyzer 7 still showed the artifact and in a deleted state. Beyond that, Mr. Green was simply stating his awareness that Cellbrite made changes to its software sometime after his viewing of the 227 AM search artifact before trial. Only the one version of the physical analyzer available to him at the time. This purported evidence of supported unreliable methodology is not about methodology at all. It's about 2 Cellbrite programs out on the market at the same time that are presenting differently about the 227 AM search artifact. That's why technology is so complicated, right? We get all these experts, we have all these tools, we have all this stuff, but at the end of the day, it feels like it's going to be confusing no matter what. And if you have smart enough people who know enough about forensic technology stuff, they can confuse anybody, including a jury, including lawyers, including a judge. It sucks. I wish it wasn't the case, but just because they disagree doesn't mean you got to strike, especially striking the one for the defendant. I just can't imagine that. It therefore does not support a basis of exclusion of any portion of Mr. Green's testimony under Robert Lanigan. So it will be interesting if Judge Cannone strikes part of his testimony. She'd have to give real specific reasons why. Commonwealth also claims Mr. Green's opinions lack any evidentiary support and cannot be made in good faith and constitute baseless claims. First, contrary to these false and baseless assertions, Mr. Green, I'm not baseless, you're baseless. Mr. Green has been, they said Mr. Green has been debunked. Contrary to these false and baseless assertions, Mr. Green's opinions are backed by significant scientific evidence. A NIST scientific foundation review and draw on the very same data contained in the new raw image file obtained from Jennifer McCabe's iPhone 11, which all three experts relied on. Second, even if the claims were accurate, the purported lack of evidentiary support the Commonwealth alleges would go to the weight and credibility of Mr. Green's opinions, not the threshold question of whether his methodology is reliable. Again, that's the Daubert question. Likewise, the Commonwealth claims that Mr. Whiffen performed a comprehensive study of the forensic data and that there is no evidence whatsoever on this device of a search conducted prior to 6:23 a.m. or of deletions. These claims are false. First, Mr. Whiffen did not perform a comprehensive study because he only looked at limited data. That's just an argument. That's an argument to the jury, right? Which one's more comprehensive? Is this actually the best tool? So if you don't use it and you're not certified, you're not doing as good of a job? Or is it better to use 5 tools? That's a question for the jury to determine credibility and which one should be believed. 2 tools, Celebrate and his companies. His analysis certainly is less comprehensive than Mr. Green, who used 5. The evidence was found on all 5 of the forensic tools used by Mr. Green, and the most up-to-date version of Axiom continues to show 227, search artifact deleted. Mr. Whiffen qualifies his statement to the contrary with, of the data I examined, meaning maybe he didn't examine everything. Third, Mr. Whiffen does not mention, let alone account for several anomalies Mr. Green discusses in his affidavit accompanying this opposition that undercut the entire December 24 report of Mr. Whiffen. We'll read that. In any event, these claims of Mr. Whiffen are no more than reiterations of his opinions and thus clearly not a Daubert-Lanigan matter, but cross-examination. Commonwealth claims that Ms. Hyde conducted an encompassing review. Again, she didn't use everything that Mr. Green used. These phrases and claims are used by the Commonwealth in its motion are just not correct. They further demonstrate a fundamental misunderstanding of Daubert-Lanigan's 2 core concerns, the province of the judge in a Daubert-Lanigan context, and the province of cross-examination and the jury. I agree, either that or they're just trying to circumvent other rules. There are not only errors the Commonwealth makes in its motion. For instance, the first footnote of the Commonwealth's papers is incorrect. Celebrate is not the leading forensic data extraction software tool. Celebrate is a company, one of the companies that provides one of the digital forensic tools relevant in this case. So this is another spot where the defense kind of falls into the trap of arguing like the Commonwealth, where it's like, okay, they said Celebrate is the best. Defense is like, well, no, it's not the best. It's one of them. It's like, that's a matter of opinion, right? Which one's the foremost? Which one's the best, right? Which one's leading? My guess is that can be a difference of opinion. It is clear that the Commonwealth's myopic focus on Celebrate Physical Analyzer is misleading and allows the prosecution to disappear the 2:27 a.m. search artifact. Despite Jessica Hyde's testimony during the first trial about the absolute pertinence and value of using multiple tools, the Commonwealth seeks to discredit Mr. Green, who did exactly that, while proffering you can tell what their cross-examination is going to be of Ms. Hyde, right? They're going to use her to bolster Mr. Green. He did exactly that while proffering experts who rely almost exclusively on Celebrate Physical Analyzer to perform their analysis. This contradiction sheds light on the undeniable effect of the Commonwealth's motion. Now discuss only one data forensic tool, Celebrate Physical Analyzer. Manipulate all Celebrate Physical Analyzer tool programs through some black box process in the electronic back room of Celebrate, so they no longer show the artifact concerning 2:27 a.m. You can also see this is kind of the argument they're going to make, that they went through some black box process in the back room of Celebrate. They changed this. They edited this evidence to fit their theory because it did not fit their theory. That's what the defense can argue. And they euphemistically label the mysterious and suspicious Mr. Green is unqualified and his methodology is unreliable simply because he does not want to play along with the manipulation of the Celebrate Physical Analyzer programs, especially in light of the Axiom program, still showing the artifact of 2:27 a.m. In addition to the prosecution's new contrived debunked narrative being false, the debunked parlance in a Daubert-Lanigan motion is inappropriate and can be seen as improper attempt to garner media headlines and otherwise prejudice future jury pools. So there will be another improper purpose if you just want the media to pick this story up. That wouldn't be proper either. I'm wondering how far the defense might go in like deposing people from Celebrate. Maybe they don't want to. Maybe they just want to make the argument, right? And be like, well, this is sure mysterious, as opposed to like, let's talk to the back-end engineers that work on Cellbrite, what made you make this change? Did Mr. Whiffen just purely come in and be like, we need to do something so 2:27 a.m. doesn't show up? Or did you really make some kind of legitimate fix that now when it runs the report, it doesn't show up? Maybe they don't want to know those answers. I don't know. But it seems like somebody at Cellbrite could explain to us exactly how this update happened. Maybe that's asking too much. Mr. Green's methodology is generally accepted in the relevant scientific community. Mr. Green's methodology was employed by the Commonwealth's experts. It is generally accepted in the relevant scientific community. Even if this court reaches the 5 non-exclusive Daubert factors, Mr. Green satisfies them. Because general acceptance of Mr. Green's methodology by relevant scientific community is sufficiently well established, this court need not reach the Daubert-Lanigan factors. However, if they do, let's go through them. First factor, Mr. Green's methodology is generally accepted in the relevant scientific community. Okay, we already read that part. Where's second? As to the second factor, the methodology and tools used are regularly subject to testing, both the experts who use them and the companies who provide them. Third, while the methods used in digital forensic investigations are often not peer-reviewed in a formal process, trustworthiness is either established by members of the digital forensic community trying out proposed methods, testing, and circulating updates within the community. And you're not going to hear the Commonwealth disagree with any of this because Cellbrite falls into the same category, right? They might not like Axiom, they might like Cellbrite, but if you're going to say Axiom doesn't fit or isn't appropriate, then Cellbrite's probably not either. I'm saying that, I'm opining that without knowing all the nitty-gritty about all these different programs. Where's the fourth one? Fourth, the methodology also does not have an unacceptably high known or potential error rate, meaning it's not wrong often. Finally, the methodology is governed by recognized standards. NASD Center for Foundation Review. Okay, same thing there. Commonwealth has not shown that an evidentiary hearing is required. So this is the big thing. You have to empower a judge to know you can deny this hearing. We do not need to waste this time and money. Everybody hit that like button if you want to read the affidavit, because we're coming up on an hour. Maybe we don't have time. If you guys don't care what a specific affidavit said, let me know. Somebody said I was glitching and they refreshed and it worked. So hit the refresh button if I'm glitching. But hit the like button and let me know in the chat writing affidavit. And if the affidavit, if you guys comment affidavit in the chat or in the comments, I will read the affidavit at the end. I was planning on it. I thought I could get this done in less than an hour though. And it looks like it's going to take about an hour. Kelsey confirms no glitching. Daubert-Lanigan evidentiary hearings are canceled in Massachusetts once papers in opposition to the request for such hearings are filed, demonstrating the lack of the need for the hearing. So they automatically set it. And then if it's unnecessary, the judge can cancel it. So, and like I said, every jurisdiction does it a little bit different, but it's so often granted that it seems like here they just automatically set it. There's a case affirms the judge's decision made on the basis of the parties' papers and arguments not to hold an evidentiary hearing and to admit the expert's testimony. So that's why you submit an affidavit, right? It's like, here's Green's affidavit. He doesn't need to be subject to cross-examination, judge. It's very clear if you read his affidavit, this is not something that's going to be struck. The core concern of the Daubert-Lanigan standard is promoting reliability by ensuring an expert has specific qualifications and employs a reliable methodology, because jurors usually give credence to expert testimony, right? And we don't, as lawyers and judges, want junk science to go in front of a jury. That's why we talked about it in the Richard Allen case, how a lot of people were uneasy about the casings matching up with just being cycled through a weapon potentially. They don't feel like it's reliable. And once you get an expert to say it to a jury, it's highly likely a jury is going to believe at least part of what the expert says because they're very smart, they're well put together, they present well, they have a good CV. So that's really what we want to prevent, is a judge allowing me to go up there and to say, I am an expert on how the NFL works. And because I watch a lot of NFL football and I play fantasy football, so let me tell you exactly what happens in the back rooms of the NFL, because I don't actually know. And I would just be talking out of my rear. That's what we want to prevent from happening. Maybe not the best analogy, but this opposition establishes Mr. Green's eminent qualifications on the subject matter in dispute and the reliability of his methodology. Commonwealth's bare and conclusory assertions to the contrary are insufficient to warrant an evidentiary hearing on the issue. The Commonwealth's motion appears to stem not from a genuine dispute over Mr. Green's qualifications and methodology, but from its transparent and disquieting campaign to deny Ms. Reed the ability to present her own defense through her own qualified and reliable witnesses to prevent the ultimate jury from receiving and evaluating evidence that is harmful to and inconsistent with the Commonwealth's theory of the case, and to drain Ms. Reed of her resources in advance of trial in the process. By submitting conclusory and insufficient motions under the guise of Daubert-Lanigan, the Commonwealth seeks to force the defense to repeatedly participate in unnecessary motions and attendant resource-intensive mini trials, thereby needlessly expending limited defense resources and diverting them from trial preparation. That is true, right? Every minute they're spending fighting these Daubert motions, they're not prepping for trial. Through this misuse of Daubert-Lanigan, the Commonwealth also effectively is obtaining depositions of defense expert witnesses, including the attempted locking in under oath of their testimony for use at trial. The instant motion and others like it are tantamount to legal tyranny, not a search for truth and justice. Now, listen, that's kind of strong because you could write that in any Daubert challenge and in any Daubert motion, right? But Daubert motions happen all the time and hearings are granted all the time. You have to prove when it's inappropriate. And I think they have some pretty good arguments here. And we just saw a glimpse of it with Dr. Russell, who I think it's much more reasonable to have a Daubert issue with her than for Mr. Green. Allowing the Commonwealth's motion to exclude Mr. Green would not only sanction this misguided and disturbing approach, but also the impermissible and intolerable adverse jurisprudence consequences of the Commonwealth's actions, which would extend beyond the instant case. Allowing the Commonwealth's motion would set a precedent that when the Commonwealth does not like a proffered expert opinion, it may file rote, vague, legally insufficient, and vexatious Daubert-Lanigan motions to exclude that proffered expert and, most important, the evidence associated with the expert. That is, the Commonwealth will make Orwellian unpersons of the evidence, which is problematic for its theory. The danger of this approach by the Commonwealth and the precedent it would set cannot be overstated and respectfully should not be countenanced by this court. For these reasons, the Commonwealth's motion, along with the included request for an evidentiary hearing, must be denied. All right, let me answer a few questions and see what the chat looks like. Okay, a lot of affidavits. Everybody hit the like button. Make sure you hit the like button and we will read at least part of it. CW wants a secure conviction instead of pursuing justice for JOK. I mean, yeah, I'm sure. I mean, in this case, they definitely want a secure conviction. Absolutely no doubt about that. But I hope that they believe that that is working towards justice for John O'Keefe. Can we pull the chat, Peter? Shut the trolls up. Guilty or not? Not the right time for it. We've already done a lot of that. We'll do it more when the trial, after all the evidence, we hear all the evidence in the trial. Sumo. Peter, why would Brennan even want a dry run when he already has the benefit of a live stream showing his last testimony? What's the difference? So great question, Sue. Great question. And let me tell you something. Most lawyers think they are the best at what they do. Most criminal defense lawyers just fancy themselves experts at cross-examination and think nobody can cross-examine a witness as well as I can, especially not a prosecutor. Most of them will say that. And they were former prosecutors, so they know how prosecutors are not all of them, but a lot of them, and they know how prosecutors are trained. And most of the time, prosecutors direct examinations is what they do most of their trial, and defense attorneys, we mostly cross-examine witnesses. So I guarantee you Hank Brennan, as a criminal defense attorney and former prosecutor and now special prosecutor, believes his cross-examination will be so much better than Lally's. He will get so much more information, lock this expert into so many other things that he will be able to use at trial. And if you get to do your own cross and you know exactly what he's going to say, that helps you so much prepare your opening statement, prepare your closing argument, prepare what your expert's going to say to counter this expert. It helps a ton, no doubt about it. I am of the mind, I think we should be able to depose all of these witnesses. I like how Florida does it in state court. I hate the the federal system where we can't depose a lot of these witnesses. And I think we should be able to depose them. It shouldn't be a secret. We should know what they're going to say. So I'm all for that. But when the rules don't allow it, you can't use Daubert for an improper purpose. But does it look for a judge to allow an expert for... how does it look for a judge to allow an expert for one trial, then strike them for the other? So if there was no objection on the first one, she didn't actually rule like she did on Dr. Russell. So it wouldn't look good. It would look kind of weird, but sometimes lawyers have very good arguments. Something has changed. We get new information. And the judge is like, hey, I got to make a different call this time. I think, my opinion in this situation, it is a pretty easy call for me to guess what is going to happen. And I don't think of myself as some legal savant or fortune teller, or like I know what's going to happen, because God knows, judges and juries, who knows sometimes. This one seems like an easy call. I am confident Judge Cannoni is going to grant or allow the hearing to go forward, the Daubert hearing with Mr. Green, and she is going to deny the Daubert motion and allow him to testify at trial. Ashley said, can you also please cover Green's affidavit? Yes, I will. Chunks of it, not the whole thing. I'm not going to read all of his education experience, but I will go through some chunks of it. Pam, the internet says Karen Reed's model SUV would have automatic backup braking. Wondering why possibly nobody is mentioning this. I don't know. I don't know the answer to this. I would think this would be a question for the accident reconstructionist experts. So we'll kind of leave it in their hands. T. Shaw, I want to hear your opinion on the email from IW. I don't know what this means. Oh. Okay. So you mean from Ian, so the state expert emailing the defense expert. I've heard people be like, that's so inappropriate. That's horrible. I can't believe they would do that. I don't find it to be inappropriate. Experts that work in the same field, they talk all the time. If he's trying to let's just take it. Let's assume Ian, what's his name? Whiffen. Is that it? Whiffen is a nice guy. And he's like, hey man, just so you know, they're going to update it and it's not going to be there anymore. So you can put that in your analysis however you want, but I'm just letting you know that's what's happening. Let's just say it was an email like that. That's fine. It's not a big deal. Now, I'm sure the defense is going to make it a big deal, like he's trying to pressure him to get on board or get out, get part of this conspiracy, or you're going to be left behind. I get that. But letting an expert in your field know that something's going to change with one of the tools that you know they use, in this case and in other cases, I don't find that to be inappropriate, personally. Isn't the Commonwealth basically telling the judge she got it wrong? No, because this one, this one was so obviously okay for them to testify as an expert in the first trial that Lally did not even object to his expert testimony. So the judge didn't technically have to make a call on Mr. Green. If they prove her Google at 227, doesn't it prove at least a conspiracy? This is why they try to block it. Oh, clearly the Google search at 227 is very bad for the Commonwealth and very important for the conspiracy theory. So I get why the Commonwealth wants to disprove it. I just don't think this is the appropriate method. What's the affidavit you keep talking about? It's an after David, and I see you saying David Reese here. Well, after David's comment, we will read this affidavit. See what I did there, David? All right, here we go. So he has multiple pages of his experience, expertise, but we're going to get into what he did on this case specifically. USF, which is his company, not University of South Florida, which maybe you guys don't think of that. That's the first thing that pops into my head because that's where I live, was initially provided with a Cellbrite report prepared by Trooper Nicholas Guarino with the Massachusetts State Police, which was labeled as a full file system extraction of an iPhone belonging to Jennifer McCabe. In the initial report prepared by Trooper Guarino, the 2:27 a.m. search for How's Long to Die in the Cold did not appear. Recognizing that this report was not the best evidence, I personally requested the image file for the phone in question, which I had reason to believe was produced using the Gray Key product based on the naming convention contained within the Cellbrite report. I subsequently received a USB drive containing the forensic image of the iPhone 11, described as J. McCabe, belonging to Jennifer McCabe, which was forensically imaged by the Massachusetts State Police using a tool known as Gray Key. The USB drive containing the forensic image was sent to USF by Assistant District Attorney ADA Lally with the Norfolk County District Attorney's Office by way of Trooper Guarino with the Massachusetts State Police. Upon receipt of the USB containing the image of Jen McCabe's phone, was assigned an internal evidence number with USF evidence number this. Notably, the USB drive containing the forensic image of Jennifer McCabe's cell phone failed to include the associated documentation containing the hash value, which is a well-known mechanism used to validate the data and ensure that it has not changed or otherwise been manipulated. After personally insisting that the Mass State Police provide the hash value associated with this data, USF was eventually provided with a PDF containing the purported hash value, and the value listed within that PDF matched the Gray Key image file of the cell phone in question. After obtaining the full file system extraction of the data contained on Jen McCabe's phone, the data images were processed and reviewed with Cellbrite and Physical Analyzer version 7 and Axiom version 6. So I don't know if he said it somewhere else or if we're going to read it later, but he said that either has never or almost never happens where he has to pull teeth to get the appropriate data that he needs to do this work. There was something else I was going to say. I don't know what it is. All right. Opinion number 1. It is my opinion, based on a reasonable degree of scientific certainty, that a user of Jennifer McCabe's cell phone searched "How long to die in the cold" at or before 2:27 a.m. Obviously, that's important. In my professional experience, hold on a second. In my professional experience, an analysis of the device's internet search history often gives valuable clues as to the user's intent or knowledge surrounding an incident. I conducted a review of the search history information obtained from Jen McCabe's phone and observed the following significant artifact from the morning in question as reported by Cellbrite Analyzer version 7 and Axiom version 6. Search term, "How long to die in the cold." Last view time / date, 1/29/22, 2:27 a.m. The URL, Safari suspended state tab, state deleted, type wall. Cellbrite processing. In Cellbrite Physical Analyzer version 4, "How long to die in the cold" search not only showed up in the web history, but Cellbrite further refined the results and included in the search items the artifact section. It was marked as deleted, as a deleted record with an adjusted last view timestamp, 2:27 a.m. Noting the inconsistencies in Cellbrite reporting between the UFED report generated by version 7 and Cellbrite's Physical Analyzer version 7, I contacted Cellbrite's technical support to inquire if they could provide additional information about this artifact. Cellbrite's technical support staff indicated that they believe the artifact was reliable and that no issues had been brought to their attention. So that's good for the defense, right? It's like, I even asked Cellbrite. They said it was reliable. But then they said no issue has been brought to their attention. So maybe they'll be able to say, well, once the issue was brought to our attention by Mr. Whiffen, that's why we corrected it. That's why we changed it. On April 22nd, 24, the Commonwealth's expert, Ian Whiffen, emailed me stating, okay, so I thought we already read the email. Here it is. He sends him an email stating the last visited time shown in PA will be getting removed from the artifact in the next available version of the Physical Analyzer. After the start of this trial in this case, in late May 2024, Cellbrite released INSIT's Physical Analyzer version 10, which removed 2:27 a.m. timestamp from its processing of the artifact. Shortly after the trial on July 22nd, 24, Cellbrite released its Cellbrite Physical Analyzer version 7.69, which also removed the 2:27 timestamp from processing of the artifact. Notably, Cellbrite is a company that markets itself as providing digital intelligence solutions for law enforcement and is used by over 6,900 public safety agencies in over 100 countries worldwide, although I am aware that Cellbrite recently changed its analyzer programs so that it no longer reports on the timestamp of this particular artifact. I have not misrepresented the data. Interesting. And also interesting because cops use this stuff a lot. They use those timestamps a lot. We've seen it in a lot of trials. So now is that going to be gone? Is it going to only be gone in certain circumstances when it's bad for law enforcement? This is going to create a whole other section in this expertise. Axiom processing. Axiom is an application product offered by Magnet Forensics, which is a competitor of Cellbrite. Best practices in digital forensics require forensics examiners to view data and artifacts with more than one tool. Therefore, I also processed the image of Jennifer McCabe's iPhone using Axiom 6.1, and Axiom 6.1 showed how long to die in the cold, last viewed 2:27. Shortly thereafter, I contacted Magnet Forensics technical support to see if additional information could be provided regarding the artifact. I was advised that the 2:27 timestamp indicates the search would have occurred sometime at or before 2:27. I mean, that's important. That's great for the defense. He called him up. He's like, is this right? Now, it does make me a little on this type of expertise. If you have to call these companies technical support and just some random person that works in technical support confirms what you did. But since my initial analysis, USF has upgraded to a more advanced Axiom, which was released December 17, 2024. And that version continues to report the above artifact, even more precise, last viewed at 465 a.m. Moreover, and it is marked as deleted. Moreover, Axiom's user manual describes this artifact as follows: Safari suspended tabs, last interaction date time, as the date and time of the current tab's state when it was last interacted with on the local device. That's pretty strong evidence. The updated Axiom is even more locked and loaded for the defense to say, this is when this was done. This date and time will reflect when the user has last interacted with this tab in Safari, or if the tab auto-refreshed on the local device only. In order to validate this timestamp, I looked up numerous examples of web sessions on Jennifer McCabe's device, including URLs containing Raining Men, Cantoma, Hawkmock Sports, and Eastern Bank. In all of these instances, the browser state.db entry appears at the end of the session. So not when it started at 227, but it ended at 227. This is consistent with how Magnet describes this artifact. In order to confirm the accuracy of this search event in Cellbrite Physical Analyzer and consistently throughout multiple versions of Axiom, I independently performed a low-level analysis of the artifact, which was located in the browser state.db wall. Write-ahead files are temporary in nature and show the location of the data is written before the commitments on the main database are made. Then this is what it showed. I used 3 additional forensic tools to conduct low-level analysis of the artifact in question, including Belkfast X, whatever. All 3 of these programs show data consistent with the search for How Long to Die in the Cold with a last view time file of 2:27 a.m. being found on record for 028. So obviously, I mean, it's just my opinion as a lawyer, and usually juries agree, 4 is better than 1, 5 is better than 4, 3 is better than 2. If you have 3 eyewitnesses, that's better than 1 that says something different. If you have 4 reports that say it was at 2:27 and 1 that says it wasn't, I think that's pretty good for the defense. It is my opinion, based on a reasonable degree of scientific certainty, that the user of Jennifer McCabe's cell phone searched How Long to Die in the Cold at or before 2:27 a.m. I have also consistently reported that the existence of 2 additional search artifacts found on the forensic image of Jennifer McCabe's iPhone, which suggests that the user of Jennifer McCabe's phone made 2 additional similar searches later that morning on January 29th, 2022. It is my opinion, based on a reasonable degree of scientific certainty, that the 2:27 a.m. search artifact, How Long to Die in the Cold, was deleted by either deliberate user interaction or manual post-imaging manipulation of the data by some unknown individual, aka maybe law enforcement, or her husband's company, whatever. It is uncontested that the 12922 227 search for artifact, How Long to Die in the Cold, found in the record is in a deleted state, meaning everybody agrees that that's how it was originally reported. Databases contained tables with numerous fields, and in some cases there is a programmed field entry to indicate whether a record is live or deleted. With regard to the browser state.db, which is the database at issue here, there is no such field to indicate whether a particular record is live or deleted. However, based on the characteristics of the data contained within the associated write-ahead log wall file, the forensic tools indicate 2:27 How Long to Die in the Cold search found in record 4028 as a deleted state. There are several reasons it may appear as a deleted state. Manual post-imaging manipulation of the data. He just explains kind of what these different things are: malfunction of the operating system or hardware, system application or operating system update, automated function of the operating system, deliberate user interaction, which means, as stated above, there's no internal field within the browser.db database to indicate whether the artifact in question was user deleted. No such field exists in the browser state.db database. However, as explained in further detail below, additional anomalies, meaning weird stuff, some strange things are going on, found on the phone strongly suggest that this data was either the result of deliberate user interaction or post-imaging manipulation. So he believes, because of the anomalies we're about to read, that it's most likely this was done purposely and intentionally. My forensic analysis of the image of Jennifer McCabe's cell phone uncovered numerous anomalies or unusual deviations from what is standard, normal, or expected in a typical case. The following anomalies further support that the artifact in question was deleted either through user interaction or through I just spit everywhere. Post-imaging, where am I? Oh, we already read this. Manipulation. Okay, anomaly 1. The most up-to-date version of Cellbrite Physical Analyzer reports 4,560 searches with only 1 search being marked as deleted. The only search marked as deleted is the most up-to-date version of Cellbrite is the How Long to Die in the Cold search found. This strongly suggests that this search was targeted for deletion, meaning it didn't just delete everything it searched on that day, right? If every 30 days your search history deletes, 100 searches would be deleted at the same time. That's not what happened here. The tab ID, and again, if you don't believe this guy and the state or the Commonwealth can discredit him, then great. But he should be allowed to testify before the jury. The jury should make that call. Anomaly number 2, the tab ID record for this This number is unique to the tab in question and would have been used for all URL history in the specific tab within this particular database. So I think what he's getting at here is some of the Commonwealth experts were like, I already explained this once. When you have Safari up, you open up your phone and it kind of reloads. It's in the same tab. He's saying this was a different tab. So that's not right. He disagrees with the Commonwealth. The Commonwealth has claimed that the actual website being visited during this period was Hawk Sports associated with that website. Thus, the records in question clearly establish that the Hawk Sports activity was conducted in a completely different tab than the search for How's Long to Die in the Cold, which also showed activity at 2:27 a.m. just seconds later, because the Hawk was 2:27 at 36. So then she opened up a new browser, but you hit that little button with the squares, opens up a new browser, and then she did this as what he says the data shows. Anomaly number 3. The Commonwealth expert Hyde and Whiffen opine that the 4028 record with the 227 timestamp initially would not have been associated with the How's Long to Die in the Cold search. I have examined the multiple writes of the 4028 record contained within the browser state.db WAL file, and in all instances, the URL containing the How's Long to Die in the Cold was present. I see no evidence that the record containing that is different or blank for that field. Anomaly 4. The search artifacts associated with How's Long to Die in the Cold, How Long T Die in Cold, and How's Long to Die in the Cold are all missing information that would be explained in the history DB file. Mr. Whiffen opines that the load was likely never successful and it was never populated in the history.db database. However, the Google suggestion for artifact for how long to digest food appears at 6:23:49 a.m. along with a picture. This indicates that the cell phone in question had internet connectivity at the time of 6:24 a.m. search and contradicts Mr. Whiffen's speculative suggestion that the load did not complete. Very interesting. The Knowledge C information for the How's Long to Die in the Cold search appears to be out of order. Knowledge C artifacts typically run a few seconds after the event in question. For example, the plist time or plist time for How's Long to Die in the Cold, or how long, whatever that one is, has corresponding Knowledge C entry of 6:23:57, 6 seconds later. Typically, the Knowledge C artifact appears second after the plist entry. However, the 6:24:18 plist entry for How's Long to Die in the Cold is followed by a Knowledge C time of 6:24:24, 6 seconds later, for How Long Tie Die in Cold. The corresponding Knowledge C entry for How's Long to Die in the Cold does not show up until hours later at 10:33:35. This is unusual and deviates from what is typically observed. Anomaly 7. Trooper Nicholas Guarino's April 24th, 2023 report shows that he took custody of the phone on 2/2/22 at 12:08 p.m. However, the gray key log indicates that the device was not accessed for imaging until 2 hours later, or converted locally to 2/22 at 2:25 p.m. The report also indicates he was given the password to the phone. Nowhere within the report does it explain the time delay between receiving the device and imaging the device. That's an anomaly, but there could be reasons and explanations why he didn't do it right away, I guess. But he just is saying 7 very strange things going on with this phone data. So here it is, officially, and why a hearing is probably unnecessary. It is his opinion based on a reasonable degree of scientific certainty, which you have to. That's the standard you have to testify to as an expert in this situation. That the 2:27:40 a.m. search artifact for How's Long to Die in the Cold was deleted by either deliberate user interaction or manual post-imaging manipulation of the data by some unknown individual. The methodology I use to evaluate the 2:27 a.m. search artifact for How's Long to Die in the Cold, as described in this affidavit, is generally accepted in the digital forensic scientific community and is consistent with the applicable National Institute of Standards and Technology guidelines as shown in Digital Investigation Techniques, a NIST Scientific Foundation Review 2022, and is attached as Exhibit B. I mean, that's really what Daubert is. Your opinions have to be based on a reasonable degree of scientific certainty, and he answers the fact that the methodology is generally accepted and explains the standards and even attaches them. So to me, it should be a pretty simple no, but I do think she is going to give him a hearing first. I do think she's going to eventually say no, but I do think she is going to give them a hearing. Can the defense demand Trooper Paul have a Daubert hearing? Theoretically, they could. People are saying I missed the importance of certain anomalies. I'm sure I did. I don't hold myself out to be a scientific data expert, and I'm sure he's going to be able to explain them better. I also have 8 minutes now until I have to get to my next appointment. So I don't have a ton of time to really dig into each one of them, but in my opinion, the factual significance of these anomalies is not really what we're here for, right? So I'm going to try to not really get into the weeds of the stuff that I don't think has anything to do with Daubert, because then you're falling into what the Commonwealth wants to is let's fight about this stuff in court, as opposed to, I don't think we need to do this. But Michelle, what I will say is it would be interesting if the defense calls Trooper Paul or uses his testimony to try to impeach other witnesses because it was that bad. Reese's mom. If the point of Daubert is to determine the witness's qualification as an expert, why do they have to disclose their testimony? Why isn't their experience, education, et cetera, enough? It's not enough. It needs to be what's their experience. Just because, like, let's just say this, okay? I have a JD. I've been practicing a lawyer for almost 15 years. So I just want to testify to whatever I want to about the law. That's not how it works. They have to say, what are you testifying to? How did you get there? What are your methods? And is it to a reasonable degree of legal certainty? And you have to fit it into those boxes. It's not just about experience, education. It's also about methodology. How'd you get there? Peer reviewed, generally accepted. And can you testify to the standard necessary in that jurisdiction? All right. That's all I got. I got to run. You guys are the best. Thanks for coming. Thanks for hanging out. Thanks for the overtime. Hit the like button if you haven't already. And I'm sure all of you are subscribed, but if you're not, make sure you hit that subscribe button. That's all we got. Till next time, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.